Yeah, good morning, sir.
Good morning. Please introduce yourself without mentioning your name.
Okay, sir. So I have done my undergraduation from Dr. Ram Manohar Lohia National Law University, and thereafter I have done my post graduation from Gujarat National Law University, and now I'm pursuing my PhD. And my main area of PhD is on women rights, and this is my first attempt in Odisha Judicial Services, and I've qualified the means. That's it.
Okay. I just want to know that you have a career which will be more suitable for academics. Then why is it that you want to join judiciary and that too Odisha judiciary to be very specific?
So actually, I was not at all interested in this career. In PhD and all in that academic career. To be honest, I just did that to secure myself for as a job opportunity, because that is the reason today I am of 33 years of age and I'm still trying for judiciary, and specifically Odisha judiciary, because till almost my entire childhood I was in Odisha, and I have special affection with that state because of the same reason. I have many childhood friends and other attachments. Like earlier, I am having some physical disability right now. Earlier, I was into Odissi dance and Odissi. I learned classical music, so I have special attraction towards the culture and the language of the state and the people as well.
Okay. Okay. Uh, um, Also, why did you not opt for practice? I mean, you could have gone for practice also.
So, as I mentioned, I have some physical disability. So, that is the reason I cannot work that much. And because that needs physical fitness, as everyone is aware of the fact that you have to be fit enough for and active enough to participate as a lawyer. Apart from that, I went to court. It's not that I never went to court. I went to court, but there I saw that people are not able to provide complete justice there. Like lawyers, we are hearing only one side of the party, and sometimes that one side we are able to judge that that person is not correct, and just for the purpose of earning, we have to support that person, and that is not justice according to me. For the purpose of earning, you have to support that person.
Okay. What are your hobbies? Please tell me.
So, as I've mentioned in my form, that my hobbies are like social work, and I'm more into spirituality, and we are associated with Gayatri Parivar. So, in which the main object of that association is to serve the society, and that is also one of the reasons that why I want to join judiciary, because judiciary is also like a association or an institution which provides social it is like a social work providing justice to someone.
Okay. Uh, yes. Can you tell me what is your favorite subject?
So I'm interested in Evidence Act, and yes, so
Okay, Evidence Act. Can you tell me what is the difference between evidence and proof?
sir, evidence is the thing by which we can prove any particular fact. Evidence is something with the help of which we prove a particular fact, and proof requires evidence. Evidence can be basically we need primary evidence to prove, which is the cardinal rule of Evidence Act, that we need a direct evidence. In most of the it is very important to have a primary evidence, but in case we don't have a primary evidence, then we rely on secondary evidence to prove a particular fact.
Tell me carbon copy, whether it is a primary evidence or a secondary evidence.
No, sir, it is a secondary evidence, but it is a primary evidence of its own self. It is a secondary evidence. It is not primary evidence. Is the evidence which is the own. It is in itself like the original thing. Like I have signed a particular document, so that document becomes the primary evidence. That is not the secondary evidence. But if I take a carbon copy, that is the secondary evidence of that.
Okay. Okay. What is the relevance of a DNA report, whether it is admissible or not?
Sir, DNA report. Okay, so sir, let me come to section 112, where the relevance of this thing DNA report is mentioned. So, sir, 112 of Indian Evidence Act is a conclusive proof. Even though it is a conclusive proof, but it is rebuttable. So, their DNA test is used. So, for the nowadays, this concept is introduced. Earlier, when the act was made, so this DNA concept was not there. So it was presumed that if the marriage is of two in the after the dissolution of marriage, within 280 days, if the marriage, uh, if any child is born, that child is it is a conclusive proof that the child is from the same person. It is a legal child. So, sir, in this case, nowadays the DNA test is used for the purpose of rebutting that fact, that whether it is a legitimate child or an illegitimate child. Because there may be cases that where 280 days even have gone after the dissolution of the marriage, and still the child does not belongs to that person. So it rebuts, even though it is a conclusive proof, but it is rebuttable with the help of that DNA test. But sir, nowadays with that Selvi, a case called Selvi, the Selvi case was introduced according to which it is the privacy of that person. So we cannot breach the privacy of the person according to the constitutional law as well. It is his right. So accordingly, we cannot use DNA test also. But it is mentioned that we can use it, but it violates his constitutional rights.
Whether a dying declaration is a substantive piece of evidence.
Yeah, yes, sir, dying declaration is a substantive piece of evidence, but in some cases it can be where the relevancy, where the it seems like it cannot be corroborated with other evidences, then it has a weaker evidentiary value. But in a general notion, it is a substantive piece of evidence. If, for example, there are several dying declaration by the same person, then the court can rely on it, but it must be coherent with each other. They should not be contradicting each other. So we can convict some person on the basis of a dying declaration.
Okay. Whether Section 27 of Evidence Act is constitutionally valid.
Sir, section 27 of Indian Evidence Act, section 27 of Indian Evidence Act talks about the discovery statement. So it is an exception to section 25 and 26, which says that if any evidence, if any confession is given before a police or in police custody, that does not hold any relevancy before the court of law. But if any statement given before the police officer, but still given before the police officer, and there is some discovery in that case it holds the relevancy, if only till that limit where only till the limit where that particular substance or that particular thing by which discovery product or whatever that discovery thing is there, that is recovered, only till the extent of that thing, that statement holds the relevancy.
Okay. A client has confessed that he has committed a crime before his counsel, and later on he changed his counsel, and then this the earlier counsel revealed this, disclosed this particular statement that he had made before him. So whether such statement is still protected under privileged communication, or with the disengagement, the privileged communication is gone?
Sir, it is still protected under Section 126 of Indian Evidence Act.
Okay. Can you tell me whether falsus in uno, falsus in omnibus is applicable to Indian context?
I am not able to recall, sorry, sir.
Okay. What is the difference between estoppel and presumption?
Sir, estoppel is a rule of law and presumption is also a rule of law. As according to estoppel, a person, the word itself suggests that the person is stopped from reverting back to something what he has already earlier said, and some other person on the basis of his statement has taken a step ahead, and later on he cannot deny from his statement that, and no, I did not say that. So that is estoppel and mentioned under section 115 of Indian Evidence Act. And whereas the presumption is something on the basis of which an inference is drawn, on the basis of which the court draws some inference. So, sir, this inference can be, there are three kinds of presumptions mainly: may presume, shall presume, and conclusive proof. So, sir, may presume is something on which is rebuttable and which is based on the facts, whereas shall presume is something which is based on the law, and that law and fact both, law and fact both. So that can be rebuttable, but mostly until and unless it is rebutted, the court relies on it. And lastly, it is the conclusive proof, and the example I already gave you under section 112, that is a conclusive proof, and section 41 is also a conclusive proof. So on that, the court almost relies on that conclusively, and that is a 100% proof kind of thing. But still, as I said, that it is rebuttable, and nowadays, like DNA testing 112, which I gave the example.
In which case, adultery was decriminalized?
So Joseph Shine versus Union of India.
Right. Can you tell me how to distinguish between attempt and preparation?
So attempt is something where we take a step ahead towards, almost one step ahead towards committing the crime, whereas preparation is like collecting the things of crime. Like, for if I give you an example, like for example, if we are if I go to a shop and I buy poison, and then I come to my home, I invite somebody. So these all comes under preparation, and then I mix it in a kheer, for example, and I serve it. The moment I serve it to him, it becomes attempt. Till then, it was preparation.
Okay. A school teacher hits a child with a stick in order to make sure that he doesn't commit such similar errors that he is committing in his studies. What offense has he committed?
So he has committed hurt.
Okay. Uh, the yes. The last question is, what is a white collar crime?
So, the white collar crimes are the crimes which are committed by the bureaucrats, and not only the bureaucrats, the higher ups, the the person who belong to the profile which are, sorry sir, I don't know this, sorry.
Okay. Can you tell me something about the Hamas Gaza issue?
So can you please come again?
Hamas Gaza war that is
Okay, no,
happening.
no, no, sir, sorry, sir. I'm not into this.
Okay. Okay. And Tell me, what do you understand by doctrine of colorable legislation?
Okay. So the doctrine of colorable legislation is what cannot be done directly cannot be done indirectly.
Okay. Can you tell me whether a same-sex couple can be allowed to adopt a child?
So, firstly, same-sex marriage is the question comes if you are adopting a child, the marriage must be legal, legitimate. It must be a legally valid marriage. So there was some issue earlier. It was declared the constitutional rights of the same-sex marriage were declared to be valid. But nowadays, sir, I have not upgraded on this. But I think there is some issue going in the parliament regarding the validity of this marriage. So if the marriage is not valid, so in that case, there may be issues, but the earlier status was the marriage was valid. So accordingly, they can adopt a child. But I think there is some issue. I have not updated myself on this. So kindly excuse me for this, sir.
Okay. Please tell me what is the difference between a tort and a crime?
Honor dot.
Tort.
No, so sorry, sir.
You do not have criminal law? I mean, the law of crimes?
Okay. You are asking tort,
Tort.
T-O-R-T.
Yes, tort.
Okay. Sorry, sir. I heard it D-O-T dot. Okay. Okay,
Okay.
sir. Tort. Sir, tort is a civil crime, whereas crime is we know it comes under the purview of criminal law. Tort is like some civil wrong which violates any civil right of the person, and whereas this criminal law is which violates the criminal rights like hurt, like grievous hurt, like something like that. And tort, under the purview of tort comes the defamation, even though is under both the laws, like assault, like battery. These are the these are not these are recognized as a kind of tort, but Indian law, we do not, it is not codified, so we cannot specify any particular thing in India, but we follow the rules of the tort law in India as well in some cases.
What is the effect of fraud or mistake on limitation?
So we can rectify that particular document if some fraud or mistake is there, and on the basis of that, limitation will also extend if the limitation is finished.
Okay. Did you have personal law or contract?
Both.
Okay. So, please tell me what is a kharcha pandan?
Sir, kharcha pandan under the purview of Muslim law is a money which is given by the husband for the basic needs of the wife, which she can spend on her basic needs.
And what is a hadiah?
Hadiya. No, sir, I don't recall.
Okay. Uh, can you tell me what do you understand by blue pencil rule? It's
No,
on the
sir.
contract. It's on the contract.
No, sir. Blue pencil. No, sir.
Okay. Okay. Thank you, Nishtha. That will be it. Let's come to your feedback.
Okay, sir.
I think we have to do some work. That is, first is you have to maintain an eye contact. Okay, you are looking
Okay, sir.
upstairs while answering, so you have
Okay,
to maintain an eye contact. That is one thing.
okay, sir.
Second is that you are over explaining.
Okay,
When I'm asking a question, you please be very precise. You
okay,
That has to be short, that has to be precise, and that has to be sufficient also.
okay,
So
sir.
that doesn't mean that you will give one word answer. If needed, you may use 4 5 sentences, but precisely it will always be about one, two, or three lines. It cannot be an extempore. Okay,
Okay, sir.
so that you have to keep it in mind, because it is a first interview. I'm sure you will work upon this. Probably try that. Yes, any question, whether you can answer that question within two lines or not, that you please check. Okay, and that too maintaining eye contacts. Other than that, I have no problems with the manner in you appear the interview, or your mannerism or etiquettes. I have no problem with that. All of that is taken care of. Communication skill is on point, so we don't have to really work on that as well. Yes, now we'll come to some questions that you could not answer. Again, having said that, probably you are underprepared. I mean, not revise, revision is not done. So we have 10-15 days more. You can revise. Still then, I'll tell you what are the mistakes that you did or you couldn't answer. Hadya is a gift of movable property. It's a gift of movable property. Okay. Kharchai Pandan is not for the basic needs, but for the expenses of betel leaves. Okay. Expenses of
Okay.
betel leaves is called Kharchai Pandan. Okay. Then attempt and preparation, you said it right, but you could use this case, Malket Singh versus State of Punjab. You could use this case. There, the proximity rule. It was said that yes, attempt and preparation. That what distinguishes is the proximity to the crime, how proximate it is to the crime. Okay. Then DNA report, you used Selvi case. No, you should have used Nandlal Vasudev Vadaik versus Lata case. That you Lata Nandlal Vadaik. Nandlal Vasudev Vadaik versus Lata Nandlal Vadaik. That is the appropriate case for DNA report. Now, next is Hamas Gaza issue. Please read upon it. Please read the news and current affairs, because here in Odisha, a lot of questions are asked from these fields. Okay, so you have to be updated with the current issues of national and important international importance. Okay, then if a school teacher hits a child, that will not be any offense, because he'll be protected under section 89 of IPC. 89 of IPC. Okay, because he's doing for his good, so he'll be protected. And the case of adoption by a same-sex couple, you might have referred to the case which is under consideration. Again, that is Suprio versus Union of India, that you could have considered by the Supreme Court. The same-sex couple, Suprio versus Union of India. Okay. Other than that, I think you could answer many questions. Falsus in uno, falsus in omnibus. That is false in respect of one, false in respect of all. That is not applicable to Indian context. That is applicable to the UK law. Okay. Other
Sir, it is
than
related to which section? I because I could not. I have read this, but I could not recall it. Falsus
so
in uno.
it says that if one evidence is, just because one evidence of one witness is false, does not mean that the entirety will be false. Entirety of the evidence will be false.
I mean, which section of
It's not
evidence
any under
applicable?
section, it's a principle of evidence.
Okay, sir. Okay.
Okay. And then yes, of course, you can link it to the section where the job of the court is to make sure that it chooses the chaffs from the grains. You can link it to that, but then it is not under any specific section. Okay. Having said that, yes, you have done reasonably well in all other questions. You could answer them, and yes, only problem with I have is you could not maintain eye contact. You were looking up
So
and
no,
you were over
actually,
explaining.
in what happened because of this online media, if you had been in my front, then obviously I would have definitely had an eye contact.
Then there is no issue. Then there is no issue. Probably I was thinking you have this habit of looking up and
No, no,
answering.
not
If
at
that's
all,
not the
sir.
case, then no issues. Okay, and please revise. Keep revising, and we will meet after 4-5 days for our second mock. Then we'll see what are the changes that are to be required. I'll again tell you. Okay,
So I
that will
want to
be
ask
a
one more thing. Yes, sir,
yes.
please.
That will be a two panel mock, so two judge panel mock. So be prepared for that. Now tell me, what do you want to ask?
So, like you asked me, what is the area of your interest? So they also ask a similar question so that I can
Yes.
prepare, I can focus on one subject
Yes.
rather than
No, no,
going.
no. You have to focus on all subjects, but sometimes they ask this question that what is your favorite subject? And then most of the questions or first initial three, four questions will be from that. So that's why prepare all, but make sure that you prepare one subject very thoroughly, which you will be which you can refer to if it is asked that what is your favorite subject.
Okay, sir. And so you asked me one question that something related to blue pencil in Contract Act.
Blue pencil rule, yes. Blue pencil rule in the Contract Act says that if an agreement contains something illegal which cannot be performed and other part of the agreement is legal which can be performed, then the part which is illegal which must be severed. That is called blue pencil rule. The part which
Okay.
cannot be performed will be severed, and the part which only can be performed, that will be performed. I think it is also contained under section 22 of Contract Act. Okay.
Okay.
It's an in English rule, but it has Indian application as well. Okay. Thank you, Nishtha. We'll see you soon. Whatever doubts, you may give me a call and we will discuss about this in more
Okay,
detail.
sir. Thank you so much, sir.
Thank you.
Thank
You may
you.
enjoy.